What's up, everybody, and welcome back to another exhilarating episode of Lockdown 23-1. Today, we are going to be entering the courtroom to witness three individuals get smoked to the core for the crimes that they've committed at a SUNOCO gas station in Cleveland, Ohio. I'm going to pin the video for y'all to watch in the comment section below of the gas station shootout, broad daylight. It's pretty crazy. And for anybody that might be new and don't know what smoke means over here, it means people get sentenced to a lot of time in prison. So prepare yourselves, ladies and gentlemen. If you enjoy, please do not forget to hit that like, subscribe, notification bell before you leave. And one more quick thing before I press play. These jets, I live right by a military base. For anybody that doesn't know, they are flying their ass off today. I'm so tired of this area. I'm so tired of this state. I got to get the hell out of Virginia Beach, man. I can't even freaking make a video in peace. If it ain't the jets, it's the police. Sirens. It's always something. But we got 18-year-old Eddie Johnson right here. He don't give two shits about my problems. He's got enough of his own. 19-year-old Maurice Watson. 27-year-old Stefan Black.
Number 634943, the case is the State of Ohio versus Maurice Watson, Stefan Black, and Eddie Johnson. This will zoom in that order.
No lamps?
Is there anything the defense would like to say on behalf of Mr. Watson?
Hold on.
Your Honor.
Did I just spot their bootleg audio?
Eddie Johnson. This will zoom in that order.
That's their audio, ladies and gentlemen? A Fox 8 microphone? Well, that explains all of our audio issues in the courtroom now, doesn't it? But there is no lamps to be seen next to these Hewlett-Packard PCs, protective custodies. What's this courtroom thinking, man? And to add some color. You can't make everything wood grain. And who's this judge fooling? That is not Diet Pepsi, that's White Lightning from D Block Cell 222. Judge, come on now.
This will zoom in that order. Is there anything the defense would like to say on behalf of Mr. Watson?
Your Honor, briefly, you heard all the facts and circumstances surrounding this case. We had a jury waiver. There's nobody who knows the facts better than you.
That court-appointed attorney sure knows how to butter those judges' biscuits up. Yes, I'm pressing pause a lot today. Every attorney, when they stand up and talk, it's almost like a skit or a talent show to the other attorneys, especially in this case. Look, there's three attorneys there. They're all going to stand up and probably try to show off their skills to the next one. But each defendant has their own attorney, and I'm breaking this down because this doesn't usually happen. Three people being sentenced, and once you got all those people in the courtroom, I'm sure there's some people out there watching that have no idea what's going on. Now, each attorney for the defendants is going to stand up and show out. They're going to speak nothing but good things to the judge about the defendant. Last-minute chances to try to persuade the judge to give him leniency.
The defense would like to say on behalf of Mr. Watson.
Your Honor, briefly, you heard all the facts and circumstances surrounding this case. We had a jury waiver. There's nobody who knows the facts better than you. I know this court very well, and I'm confident that you will make an independent decision as far as the penalty that is going to be imposed on Mr. Watson. I certainly hope that the court would not punish him for exercising his constitutional right to go to trial. It was a brief trial. I doubt that he is going to have much to say on his own behalf at this point in the proceedings, Your Honor.
I hope the judge doesn't judge him because he used his constitutional rights to go to trial. You know, a lot of people that work in the system, they're not going to say this out in the open, but this is just like an unspoken rule. They can't stand it when you waste their time and take shit to trial when you know for a fact you are guilty.
He has indicated to me that he is indigent. He wants to pursue an appeal, and I'm sure the court will appoint another attorney on that and provide the transcript at state's expense. He's been incarcerated for an extended period of time. I would ask the court to waive any court costs, and at the conclusion of the proceedings here today, I will have him sign an affidavit of indigency. But, Your Honor, there's not much to say other than he's 21 years of age. His criminal record is confined to one juvenile conviction. There seems to be some drug and alcohol misuse in the picture here. He was working at the time of the offense, and I'm certain that the court will take his age and relative lack of any involvement with the criminal justice system into account.
Thank you. Mr. Watson, is there anything you'd like to say on your own behalf?
Oh, sir, I just spoke with him.
Thank you.
So he's indigent. For anybody that doesn't know what that means, he's pretty much ain't got a pot to piss in. He probably doesn't even have a honey bun in his cell waiting for him after he gets smoked. But he has an attorney that was appointed to him by the state. And you can only imagine how well could that work out for you if they work for the state, you know? But it is what it is. He has proper counsel. And he's broke. You know, he's going to probably appeal, get a whole nother court-appointed attorney, and all expense of our tax dollars.
On behalf of Mr. Black, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Obviously, this has been a difficult case for the community as well as the court and all of the young men sitting at this table. I've had the opportunity to address the court at the time of Mr. Black's plea. He did accept responsibility, and moreover, he indicated to the court what I will remind on the record was that this was a situation that went completely awry. He never planned. This was not supposed to be some kind of gangland violence or shooting in the community, which unfortunately is what occurred. And thank goodness no one, the little girl.
You can tell you wear a wave cap too, man. You ain't getting no waves on that lake.
No one was killed or injured. In fact, Mr. Black, perhaps his
It's like the Dead Sea up there.
the most significant injury of all, given the fact that he was shot and is still undergoing treatment for the colostomy bag that resulted as a result of this incident.
Oh, he got
Mr.
shot.
Black was carjacked a day or two prior to this incident at the gas station by two of the named victims in the case, and he was upset. They took his car and his money for his kid's Christmas. And he intended this situation to be some kind of just stopping the gangland violence that has been occurring at this gas station. We have asked the owner of the gas station who manages it to come, and I indicated to the court that I believe he's going to be arriving shortly. He left the gas station. And the only reason is not because he's denying any responsibility for this incident, but we wanted the court to get a picture because it's been described, and especially in the media, as if this is some kind of robbery, aggravated robbery, and that these events are what causes the neighborhood to be at risk. And we accept that Mr. Black was a part of an incident that was very dangerous and risky, and again, he's accepted responsibility. But what we want the court to also know is that this is his community, and he also lives there and has to face, as well as members of his family, the other violence that unfortunately was a part of this. And how he acted and what he did to try to stem what had been going on was obviously a mistake and unfortunate. He can only indicate to the court his sincere regret.
He is over here trying to say he's pretty much playing Batman. That he's trying to deter gang activity and gang warfare in his area by shooting back. His attorney's using the whole poor, hopeless me lines. He was just carjacked the day before, Your Honor.
And his attempt, he was the first person to plead in connection with this case as far as the main defendants. He's been given the privilege by
He was the first person to drop down, probably.
address his injuries and his medical attention, which are ongoing. He has scheduled for surgery on June 20th as a final procedure to repair the infection and the situation that occurred while in the jail since December of 2017. So, Your Honor, we would ask the court to consider the purposes of Ohio Revised Code 29 and the overriding sentencing. This is not the worst form of the offense, given the fact that fortunately no one was injured. It is a dangerous situation, and he has a minimum sentence of 9 years, which given his
minimum
injury, as well as 9 years being away from his family, being able to work and support his kids, is a long time. We would ask the court to take all of those things into consideration, and we would ask you to consider the minimum sentence of 9 years or a sentence that is close, and we would indicate that a person who's charged with murder without any kind of aggravating factor would face a minimum sentence of 15, obviously with a life sentence. He's going to be on some kind of supervision and parole by the adult parole authority, certainly mandatory upon his release from jail. He does have minor children. He's active, involved in his life. Both his parents and his siblings are here in the courtroom. They have been a part of his life, and he feels not only has he let himself down, his family, but he does continue to have all of their support. So we would indicate to the court his regret, his responsibility for the actions in part that occurred in that day, and ask for leniency in your sentence. Thank you.
Thank you. Mr. Black, is there anything you'd like to say on your own behalf?
I would like to apologize to the court, to my community, to my family, and to the victims, and to everybody that's involved into this case. I'm taking responsibility of everything that happened, but it did not supposed to happen like that. And I regret that it happened like that. And I'm very sorry for the little girl being grazed. I'm very sorry for that.
Well, he actually spoke with a little more common sense than I thought he would. He looked really out of it, man, when he was just sitting there. But yeah, I don't know if I told y'all, a little girl got grazed on her middle finger by a stray round.
Thank you.
I don't like how the attorney tried to bottleneck everything, like him being shot by the other people, into his punishment scheme of things. Yeah, he's been shot, 9 years away. I mean, all this stuff, taken into consideration, Your Honor, is enough punishment. He don't care if he got shot. That wasn't the punishment the judge has to give him. No judge would ever take that into consideration when it comes down to sentencing. He got injured on his own free will.
On behalf of Mr. Johnson, is there anything you'd like to say on his behalf?
Thank you, Your Honor. On behalf of Mr. Johnson, I will first, Your Honor, like to incorporate, as this court is aware, I did file a sentencing memorandum on behalf of Mr. Johnson, as well as the statements that were just made by both prior counsel as it relates to the facts and how my client found himself involved in this situation. I will not belabor the point, but the court knows that this was an incident that my client echoes that definitely spiraled out of control, but the true intentions from the beginning was not to have this happen. I can tell you that I have had numerous discussions with my client over the course of this case, and I can tell you that he stands before you completely remorseful for his actions and ready to atone for his actions on that day. That is evidenced by him accepting responsibility for his actions in this case and pleading guilty and standing before you now waiting on his judgment. As far as him as an individual person, I can tell you that Mr. Johnson is 19 years old, Your Honor. He has had ties to this community and the very community in which this incident occurred for his entire life. I can tell you that it has been a very eye-opening situation for Mr. Johnson. In my discussions with him, he has relayed both his remorse and his eagerness to put this situation behind him to show that he can be rehabilitated and when he returns to this community to be a productive member of the community which he loves and he grew up in. I can tell you, Your Honor, that you are very familiar with the purposes and principles of sentencing, and looking at those purposes and principles, the things that I've outlined and which were outlined in my motion, we believe weigh heavily in the fact considering in the factors into the court considering a minimum sanction or something very similar. The court is well aware that the minimum sentence in this case is 9 years. I point to the fact that Mr. Johnson is 19 years old. Your Honor, as this court is aware, these are very formative years in an individual's life. And the fact of the matter is that he is going to spend the majority of his young adult life behind bars.
So what? I did. Look at me.
Gotten himself involved in this situation, and it in fact has taken him away from his own child who will grow up without his father being present in his life. I can tell you that he's completely apologetic to all the victims involved, apologetic to the community, apologetic to his family for taking them through this.
Man, that guy don't give two shits. She's saying he's completely apologetic. He's back there cracking his back and stuff, ready to go eat that half of ramen and lay it down.
After the consideration of the record, oral statements made today, the pre-sentence report, the purposes and principles of sentencing.
After considering the records, the words spoken in the courtroom today, the pre-sentence report, I mean, the pre-sentence report is probably the most important, ladies and gentlemen. If you don't know what that is, it's a point system. It gives the judge a rule of thumb on how he should be sentencing these individuals based upon their age, the crimes, and some kind of, program or artificial intelligence that they got calculates their points and how much time they should be getting.
The seriousness and recidivism factors relevant to this offense and this offender, and the need for deterrence, incapacitation, rehabilitation, restitution. It should first be placed on the record that counts 3, 4, and 9 are all allied offenses, and we merged into count 8. Is that correct, Mr. Rubelski?
9 would merge into count 8.
9 would merge into count 8, and 3 and 4
Into
merge
1
into
and
1 and 2.
Respectfully, yes.
All right, fair enough. And this is ordered. The defendant served 9 years in prison on counts 1 and 2, plus an additional mandatory consecutive 3 years for the gun specifications. With those terms to be served concurrently.
That's an 11 clip. He got 9 years for charges 1 and 2, and he got a mandatory 3 for the gun spec, all consecutive. Not concurrent, ladies and gentlemen. That means he has to do the 9, and then when he's done, he does the 3. If it was concurrent, then they would have thrown the 3 with the 9, and he would have killed 2 birds with 1 stone. Only had to do 9 years. What'd I tell you? If it ain't the Jets, it's police sirens. I gotta get the hell out of here. I gotta go to the mountains. I gotta get me a real compound. I'm tired of this shit. But this guy's got 11 years worth of smoke so far. What else is in store for him behind that Hewlett-Packard and that White Lightning Pepsi diet? Come on, Judge, you know that's a lie.
And 7 years in prison on counts 6 and 8, plus an additional mandatory consecutive 3 years for the gun specifications, which must be served consecutively. Counts 1 and 2 by application of law.
Welcome to
And 36
Sizzlers.
months on count 13 to be served concurrently to all of the other sentences for an aggregate total of 22 years in prison. Defendant is ordered conveyed to the custody of the Ohio Department of Rehabilitation and Corrections forthwith. Credit is granted for 192 days spent in custody in this case prior to sentence together with future custody days, while the defendant awaits transportation to the appropriate state institution.
22 Blickums, ladies and gentlemen. You see how the dude's attorney, the lady with the white jacket, I don't know if you remember what she said, but one of the defense mechanisms she was using was, look, Your Honor, even in murder cases, the bare minimal is 15 years for murder cases. And this was nothing like a murder case. No one lost their lives, so he should get nowhere near 15. Well, the judge sees otherwise, or shall I say the pre-sentence report, I don't know, because he just got 22 of them janks. All 3 of them, the SUNOCO trio, smoked to the core. But anyways, ladies and gentlemen, I hope you enjoyed entering the courtroom once again today. It's been a while. We might have another one tomorrow, I'm not sure. Got quite a bit. I'm backlogged. A lot of people have been sending me clips of these court sentencings lately, but let me know, do you think 22 years is enough or too much for... I mean, you'll see. Go watch the damn video that I'm going to have pinned in the comment section below, ladies and gentlemen. Don't forget about it. It's a surveillance video. But come back and let me know your thoughts in the comment section below. These jets are flying. I got to get out of here before I lose my mind.